I want to get some information about filing bankruptcy in Florida. Why do so many people file bankruptcy today? People need to file bankruptcy for many reasons. Some people lose their job, some get divorced and get stuck with their spouse's bills, some people have a medical problem, and other people file because their houses are upside down and they face foreclosure. Can anyone file bankruptcy in Florida? Anyone who has lived in Florida for 3 months or more may be able to file bankruptcy in Florida. I read about different bankruptcy chapters. I am confused. What is difference between Chapter 7 and Chapter 13? It is easy. Chapter 7 wipes out all your unsecured debts such as credit card debts and medical debts, but you have to give up any property which is not exempt under Florida law. Chapter 13 is a repayment plan where you pay back to your creditors what you can afford to pay based upon your income and expenses. That is easy. Now, will bankruptcy save my house from foreclosure? Chapter 7 does nothing to stop foreclosure. If you do not pay the mortgage, you'll lose the house. But, in Chapter 7, the mortgage company cannot pursue you for a deficiency. Chapter 13 may help you with your house by either giving you time to catch up missed payments or in some cases wiping out a second mortgage. I think I need Chapter 7. I have lots of credit card debts but my house is hopelessly underwater. Okay, what do you want to know about filing Chapter 7 bankruptcy in Florida? Do all Florida residents qualify to file bankruptcy? Not everyone qualifies to file Chapter 7. First, if you are really poor, you automatically qualify. How poor do you have to be to automatically qualify for bankruptcy? So, if your family income, based on the last 6 months, is less than the Florida median income for your family size, you automatically qualify. If your income is more than the median income, then you have to take and pass a means test, which a test Congress created to see if you are still poor enough to file. Is your income based on last year's tax return? Bankruptcy income is determined by the total gross income during the past 6 months earned by everyone who lives in your house. If you own your own business, do you include the business gross income? No. You include only the money you received from the business as salary or distribution. The means test deducts business expenses. What else is included in income for bankruptcy purposes? Your wages, of course. Also included are rents from property, IRA distributions, money earned by anyone living with you, and all income from any source. Family gifts are not income, so that does not count. Okay, so if your income is less than median income, then you are okay, and if you are above median income, then you have to take the means test. So, how does the means test work? It is complicated. You need a computer program to figure it out. Basically, you start with the same income number. Then you deduct secured debts like mortgages and car payments. Then you deduct standard expense allowances that Congress came up with, and then you deduct other actual reasonable expenses such as medical costs, insurance, necessary child care, charity, reasonable entertainment, and other things. If the bottom line net income number is low enough, you pass the means test and you can file bankruptcy. You fail the means test. Then what happens? Some people have to file Chapter 13 if they fail the means test. But other people can still file Chapter 7 bankruptcy under some exceptions. How can that be? I thought you had to be poor to file bankruptcy. Not exactly. If the amount of your debts for non-consumer things like personal guarantees of business leases and supplier contracts, taxes, student loans, and investment real estate is more than the amount of your personal debts like your home mortgages, car loans, and your credit cards, then you can file Chapter 7 bankruptcy regardless of your income and regardless of the means test. That means that millionaires and billionaires making more than $250,000 each year can file bankruptcy if they have mostly business debts. That is right. Okay, you qualify for bankruptcy. Do they come to your house and take all your stuff? No. There are many things that you get to keep. The assets you keep are called exempt assets. They include your house equity as long as you pay your mortgage, all your retirement accounts, your salary and wages if you are head of household, and in some cases, financial accounts you own jointly with your non-debtor spouse in the cases where just one spouse files Chapter 7. There are other exemptions in the Florida statutes, and your attorney will explain them. What about my furniture? Each Chapter 7 bankruptcy debtor can exempt $1,000 of personal property such as cash in the bank, furniture, clothes and other household stuff. A married couple can exempt $2,000. Is that all? That is not enough money to live on. It is not fair. Don't worry. The values of your personal property is based on garage sale value or liquidation value, not what you paid for it or the replacement costs. Do I have to list everything I own? Yes. Usually, the bankruptcy trustee accepts what you list on your petition. However, in a few cases the trustee may inspect your home, so you need to list all your possessions. Can I keep my car? I just paid it off, and I need the car to get to work. You get to keep $1,000 of car equity. $2,000 if you own the car jointly with your spouse. I will not give up my car. You can keep your car, but you have to buy back any non-exempt car equity from the trustee. The trustee usually gives you 10 or 12 months to buy your car equity. Is that the best you can do? Well, there is something else. If you do not own a home, or you do not claim a homestead exemption either because your home is upside down or because it is exempt for another reason besides the homestead exemption, then you get an additional $4,000 exemption per person which you can apply to your protect your car or your other money or personal property. It is called a wildcard exemption. Thank you. So, how do I get started and how does this work? First thing to do is meet with a bankruptcy attorney to make sure bankruptcy is your best solution. Keep in mind that for people with significant assets have less protection under bankruptcy law than they do under state laws outside of bankruptcy. Bankruptcy is a last resort. So, you need to make sure that filing bankruptcy is absolutely necessary in your particular situation. If you are smart, you will ask your attorney if you have other alternatives. Assuming I have no choice other than filing bankruptcy, and that I qualify for Chapter 7, how does it all work? Your bankruptcy attorney will explain the details. Bankruptcy attorneys are required to give you a bunch of paperwork at your first meeting. Then, most attorneys will give you a questionnaire to fill out. On the questionnaire, you will list all your debts, all your assets, income and expenses, and answer a bunch of other questions the government wants to know about you. I understand. So, I just have to fill out the questionnaire and I am protected from the creditors. Not exactly. You also have to give your attorney a lot of documents including pay stubs, tax returns, proof of identity, and some prior month's check statements. Then what? The attorney's office will prepare the bankruptcy petition and send it to you to review. You sign the petition and deliver or send it to the attorney so he can file it electronically with the court. You did not mention money for the attorney. Attorneys do not work for free. You have to pay the attorney in full plus filing fees before he can file your petition. Bankruptcy attorneys have to be paid before you file in order to avoid being one of your creditors. No attorney can collect fees after you file a Chapter 7 bankruptcy. As soon as you file, the bankruptcy court will issue a form called a notice of commencement to all your creditors. What does that mean? The notice warns all your creditors that you filed bankruptcy and tells them not to bother you. The notice also gives you the name of your bankruptcy trustee and the date and time you have to meet the trustee. I do not want to meet any judges or trustees. The law requires you meet a trustee at a creditors meeting. The trustee will ask you some questions about your bankruptcy petition. Do you mean that all the creditors show up at the meeting to harass me? Your creditors usually will not come to the meeting. The trustee is there to represent the creditors and to see if you have any non-exempt assets. The trustee's job is to get all the non-exempt assets and distribute the proceeds among your unsecured creditors. Is the trustee mean? Some are pretty nasty. Some are more reasonable. Different trustees have different approaches, just as different attorneys will give you somewhat different advice. Most trustees are good people trying to do the best job they can. When will I know if there is a problem with my case? If a trustee has an issue with your bankruptcy, the issue will probably come up at the creditor meeting. The trustee has a limited time after the meeting to challenge your asset exemptions or to do other things to recover non-exempt assets. When is it all over? If the trustee does not raise any problems, and they usually do not find problems, then you can get your discharge 60 days after the meeting, and the court will close your bankruptcy case a couple months thereafter. What happens to me after the bankruptcy? Can they go after money I make in the future? No. Anything that happens after you file bankruptcy does not affect your bankruptcy case. For example, if after you file your petition you get a great new job and make over $250,000 a year, you get to keep all the money and the creditors cannot even ask you for payment. No way. It is true. The purpose of bankruptcy is to help you recover financially and do better in the future. You keep the money. This is very encouraging. I feel better now. Thank you for the very good explanation of bankruptcy in Florida.